introduce today's guest and our host, Alan Schnurman.
Welcome to Lawline. Today we have a very informative show for you. We'll examine two areas of real estate law. One, guidelines to follow in purchasing a home, co-op, or condominium, and landlord-tenant law and the problems resulting from it. With us to share their expertise are Judge Israel Rubin, Administrative Judge of the Civil Court for the City of New York. Also joining us is Gerald Colston, a member of the firm of Goldberg, Weprin, and Houston, and a specialist of landlord-tenant law and real estate for over 14 years. Also Arthur Weiss, a partner in the firm of Weiss & Weiss. Arthur is a frequent lecturer for co-op and condominium groups throughout the state of New Jersey. Welcome, gentlemen. Arthur, when someone buys a home, is there a checklist of things they should be looking for?
Well, Alan, not really a checklist. When someone initially is in the process of looking for a home, they will usually be consulting with a realtor, and they will have a preset notion of things they would want to find in a home based on their own ability to purchase the home, whatever the price range is. And with those set ideas, they would then work with a realtor and then choose an attorney as they would go into the process of selecting and going to contract on a home.
Does it differ for co-ops and condominiums, Jerry?
Not basically. A person is going to evaluate what they think is going to be a good purchase or not. They will have a checklist of what's included in the sale or of the particular apartment, how is he going to finance it, and what the price is going to be.
Judge, on just a slightly different topic, when a person is a renter of apartment and they get served with legal papers that say summary dispossessed for one reason or another, maybe they missed their rent or they're a few weeks late, what should they do?
The first thing they do, you try to get an attorney. However, it's not a necessity. The second thing you do is you run down to the courthouse and put in an answer, because if you don't answer that complaint, it could be a grounds for eviction.
Well, don't they have to give further notice before a marshal or a sheriff actually comes and throws you off the premises?
Well, that's down the line a little bit. A marshal has to give you what we refer to as a 72-hour notice. However, if you ignore one paper, you're probably going to ignore the other one, and it's a very dangerous thing to go down to the wire.
How much do attorneys charge representing people in real estate matters, Arthur?
Alan, that's probably the most frequently asked question we have when people consult us in our office for review of a real estate contract. The initial question is, Mr. Attorney, what are you going to charge? And I can only say this. There are certain parameters that we certainly can explain to the client when the client first comes into the office. But the real question should be, what is the ability and the expertise of the attorney in real estate law, and will his fee be based on that knowledge and expertise? For instance, you would probably not want a practitioner who specializes in matrimonial law to handle a very complex real estate transaction for you. And that being the case, the real estate practitioner realizes that, explains that difference to the client, and will explain to the client that the fee will be based, could be on an hourly basis, could be on a flat fee, but it will vary from practitioner to practitioner based on that individual attorney's expertise, length of practice in the area, and overall knowledge and help in the transaction.
Arthur, you answered that like a lawyer, but for the viewing audience out there, they want to know if I'm buying a $75,000 house, and if I'm buying it in Nutley, New Jersey, and if I go to one of my local attorneys, what price range should I be in?
Well, Alan, I wouldn't give a price range because that could be misleading. But let me say this, that it is of no difference, no consequence in our office whether you're buying a $75,000 home in Nutley or a $500,000 home in Saddle River. The work product that must be done can vary on many factors. It's easy to give a fee quote, but there may be certain title problems, for instance, that arise in the process of inspecting the contract and eventually closing the home. And it would be best to give a parameter where the fee would be, and then potentially there would be extra fees beyond that if a problem was encountered.
Oh, thank you. Jerry, Arthur raises the word title insurance. What does that have to do with a co-op, a condominium, or purchase of a home in New York City?
Well, you've raised three different areas, and they each require different response. Cooperative purchases of apartments, many people think are buying of real estate. In fact, you're not buying real estate, you're buying personal property. You are getting shares of stock and a right to occupy the apartment pursuant to a proprietary lease. On those situations, you don't need title insurance. What we normally do is run a judgment search to be sure that the seller has no outstanding liens that could then be attached to the proprietary lease and stock, but you don't have to go through the expense. Condominiums, on the other hand, are pieces of real estate and are deemed so in New York. And for that, we do run a standard title search, as you would for a purchase of either a home in New York City or a building if you were buying that for investment.
Judge, what are the common areas, the common problems you face in the landlord-tenant situation? Are there a majority of matters?
Well, the big problem we do face is the volume of matters that comes before the court. The civil court, of which I'm the administrator of, is referred to as the busiest court in the world. And that is partially because of the housing court, which is contained within the civil court. We take in, just in the housing court, some 400,000 matters each and every year, and that's a lot of cases.
To combine two areas, which we're doing today, co-ops, condominiums, house closings, and landlord-tenant, there's one thread question that runs through my mind. In the condominium, in the co-op field, in the conversion field, here in New York at least, the rent stabilization law requires that the person be a resident. I know many people are receiving summary dispossesses or letters of eviction or cases to bring you out of your apartment based upon the fact that the landlord says you're not a primary residence. What's the story there?
Well, the rent stabilization laws play very little effect today. We have a new law in New York referred to as the Omnibus Housing Law of 1983, which was slightly amended in 1984. The Omnibus Housing Law refers to something that we call primary residence. You now have a problem if you are not what we refer to as a primary resident. In other words, let's assume that you live most of the time in Florida and just come up here during the summer months. You could not be referred to as a primary resident, and the owner or the landlord would have a grounds for not giving you a new lease when your present lease expires.
Well, let me ask you this. If I have a home, and I'll address this to anyone who answers, in Connecticut, a second home, and let's say I have my car, I have it registered in Connecticut, and I have a Connecticut driver's license, does that mean I could possibly lose my New York City apartment?
I think the answer is, Alan, that a couple of questions you have to analyze in terms of primary residence. What is a primary residence? One of the key questions that came about in 1983, and it was enacted prior to the Omnibus Housing Act of 1983, but was enacted in terms of legislation proposed by Mayor Koch, was where do we file our income tax returns? Unfortunately, this law that was passed then became codified more clearly in the Omnibus Housing Act of 1983, and what that did was that took out of the administrative agencies the issue of primary residence and put it in before the courts. And the courts have used the criteria of saying that a place where you file your income tax return is a good indication of where you are primarily residing. But it is not the whole answer, and the court, in reviewing the issue, can question it. So when we say if we have a home in Connecticut, the real question is are we paying income tax in Connecticut? Are we trying to somehow subvert where we are living in order to gain an income tax advantage? It's not an absolute area or answer, but it is a key question that the court will look at.
So can I get an opinion from you? If I have that second home in Connecticut, and let's say I have a Connecticut driver's license, and the car's registered there, well, do I have a problem? Am I going to lose my apartment, which I'm paying under market rent, which possibly is going co-op, which possibly is worth thousands of dollars more?
I'll get them off the hook fast. You may have a problem.
I was going to say, if you add to that income tax returns being filed, I would say you definitely have a problem.
Okay, but based on that, you think there's questions here, is that correct?
There are certainly questions to be answered in today's times.
Okay. Arthur, what's the landlord-tenant situation in New Jersey? How does someone If they have an apartment and the person's not paying rent, what's the procedure there?
Well, it's comparable to that in New York. Obviously, if rent has not been paid, then the landlord has the right at that particular time, without even a notice provision of 1 month or 3 months, to simply draft after a notice of non-payment, after notifying the tenant that payment is requested and not receiving appropriate payment or response. At that time, the complaint would be filed, and there's no notice provision such as a 3-month for a holdover tenant, or for even a 3-day notice, as you would have in someone who is either destroying the premises or not abiding by the rules set forth in the lease. But basically, and you will find this in most of the cases, those rights and obligations are clearly set forth in the lease document itself.
Judge, what happens if I come home from vacation and I see that my apartment the lock has been changed, my stuff is in the basement of the building, and the landlord says, well, you no longer have an apartment here. You were a week late in your rent, and I cleared out your stuff. What can I do?
Well, that we refer to immediately as an unlawful eviction. You can only be evicted through lawful procedures taken through the courts, and an eviction order, or a judgment as we refer to, taken in the court. The first thing you do, again, you try to see an attorney. And if you can't afford an attorney, there are various organizations that will attempt to help you. But you must bring a proceeding to take that landlord into court and to get back into the apartment. The first thing you do is you will try to get what we refer to as an order to show cause, with a right of re-entry in which a judge will order that possession be given back to you.
Judge, it sounds expensive. Can I do that myself as a person if I can't afford a lawyer?
Most certainly. As I told you a little while ago, there are roughly 400,000 proceedings in the housing court. I would say that 85 to 90% of them are brought by people that do not have lawyers. When I say people that do not have lawyers, I'm referring predominantly to the tenant side, not the landlord side.
With such a heavy volume, how long does it take to evict somebody in the city of New York?
It depends on each and every case. I can't give you a guideline as far as a few weeks, a month, 2 months, etc. Every case is different, Alan.
Jerry, under this new Omnibus Housing Act that everybody's talking about, which the judge discussed a little earlier, if I'm a rent-stabilized tenant and maybe I'm moving, maybe I'm not moving, I'm thinking about it, but mostly I'm thinking about that my building possibly can go co-op. And I know I had a friend and his building went co-op, and he made tens of thousands of dollars because when it went co-op, he turned around next week and he sold the co-op for more money than he paid for it. And I don't want to lose this privilege, this added thing. Well, but I'm thinking of moving. What can I do?
Well, clearly, if you're asking, can I sublease and hold on to my rights to my
I
apartment,
think that's what I'm asking.
the key question of that is, and as really defined by the Omnibus Housing Act, is when I want to sublease my apartment, am I intending to return to that apartment? In order to have a right to buy, you have to be a primary resident. In order to be a primary resident and sublease, you must show that you intend to come back to your apartment. If you can show because of business or an occupation that you were going to be out of the country or out of New York for a short period of time, then surely you could sublease, hold on to your rights to the apartment. If you are holding on your rights to the apartment, clearly for the financial reward, with no intent to return, you could lose your apartment.
Jerry, let's assume that I want to retain the apartment, I want to return, I want to go to Europe for a year or two and come back. What actually do I have to do to preserve my interest in that particular apartment?
You have to continue to become and remain a tenant of that
I
apartment.
understand that. Do I have to send a letter to my landlord that I wish to sublet? Do I have to give financial information of the new tenant?
All right. Under New York law, under Real Property Section 226B, there is a procedure outlined of how a tenant subleases. He is to write to his landlord by certified mail return receipt requested, advising the landlord that you want to sublease the apartment, setting forth the name of the proposed subtenant, a copy of the sublease agreement, and key, the reason why you are subleasing. When the landlord receives that notice, within 10 days, he has the right to ask for additional information. That additional information can't be burdensome in nature, but it can inquire as to financial information. If the landlord doesn't ask for that information, he has to make a decision from 30 days from the original request.
Judge, what is the situation regarding SROs, single-room occupancy only? Can you be evicted from that? Can't you be?
Well, you can be evicted from it, and they represent a very, very serious problem in New York. And basically, the serious problem has resulted from the numerous violations that occur in SRO residences. But they have the same problem that you have in general in housing today.
Arthur, regarding New Jersey, and that's basically your area, do you have these co-op and condominium problems, and what problems are unique to your state?
Well, the problems that we have, we do not have the Omnibus Act that you have. We have a New Jersey Condominium Act. And, you know, Alan, we have now in Atlantic City, we have a great number of very valuable properties that can be taken over and turned into co-ops and condominiums, which would be unique to that particular area, to Atlantic County, because of the value of these particular units. And I would say that the problems that we have there are if the individuals who are located in these particular buildings cannot relocate, we have a great displacement of a number of people. Consequently, we have currently a very stringent notice requirement when a building is going to be either turned into a condominium or into a cooperative building. And we also have a very good revision to our statute law that allows for the protection of either disabled or senior citizens being those people designated as 62 years or older at the time of the conversion. This is very important in that area because we're seeing a great upheaval in that area. And that is, I think, the real uniqueness that we have in New Jersey as opposed to your particular situation in New York.
But Arthur, I do notice a similarity between Atlantic City and the prices of real estate zooming and Manhattan, whether it's the east side or the west side of Manhattan, where people, senior citizens and otherwise, have been residing in their apartments for years. And it's the landlord or a new landlord who's taken over recently who's going to convert his apartment, convert the building, and perhaps looking at it at a substantial profit. And it's in his interest to get the tenants out. Recently, there's been a lot in the newspapers, Judge, about landlords of this nature and the course of conduct that they've been taken. I even read in one thing there was fines or even a criminal problem. Can you discuss that?
Well, there has always been a certain amount of harassment between landlords and tenants. You find with the co-op situation there's a little more going on because, as you have pointed out, the huge amount of dollars that are to be made today by co-oping an apartment. The landlord-tenant relationship has always been an emotional relationship. In fact, when I speak to groups, I refer to it as the second most passionate relationship known to mankind. I can tell you right now it has not been helped by the co-op craze. Not only do you find the harassment problems that we have, you also find now problems arising between co-operators, those that have bought into co-ops, and those that have sought to stay under the rent stabilization laws on the so-called non-eviction plans that we see predominantly today.
Jerry, I know in these condominiums and the co-ops, people are purchasing the rights to those units and they don't even live in them. And they actually have a tenant who pays them rent, and they in turn pay the co-op board or the condominium board, I would assume the maintenance. Are there any problems that are peculiar to this situation of a landlord who has only one unit?
Yes, there are, Alan. And by the way, it's a very new area, and I assume that the problems will become much more drastic, and I'm sure the judge will have to deal with these kind of situations down in the landlord-tenant court. Because all of a sudden we have an investor, maybe not very sophisticated in the real estate world, who has now become a landlord. as a landlord, he's obligated to maintain and repair the apartment. Here you have a tenant who is a stabilized tenant or a rent-controlled tenant living in the building, having gotten certain services. Something goes wrong in his apartment. Where does he turn and who does he go to? These landlords who are investors are not equipped to really handle these situations, and it has created, and in my opinion will create, substantial problems. As a matter of fact, recently there's a new managing agent firm that has been established who are now representing these investors who are taking on this kind of obligation because these people are totally not equipped to handle it.
Judge, how does one go about, hey, you're the administrative judge, selecting an attorney who knows real estate law? What's your recommendation to our viewers who find themselves either needing to buy or to sell, or even a situation where they're being evicted or they want to evict someone? How do they get this lawyer?
I would advise them to contact the local bar associations. The bar associations usually know the attorneys that specialize in some form of real estate law, and they would be best to consult as far as any referral is concerned.
Jerry, is it your opinion also, if somebody's involved in real estate, they should take a lawyer who specializes in this area?
Absolutely. And in that, you have to then define the specialization in real estate. The lawyers who do exclusively landlord and tenant work today has become a separate area distinct from lawyers who are representing people who buy buildings or co-ops. You need a specialized expertise in handling each of these matters. New York has a tremendous volume of cases in landlord and tenant. As the judges noted, you need a lawyer who is experienced in that court and knows the mechanism of the court.
Arthur, do you have any agencies in New Jersey you could recommend?
Well, you certainly, as the judge has said, you can certainly go to not only your New Jersey State Bar Association, but you can go to your county bar association, Bergen County. You could refer to the bar association offices in Hackensack. I think certainly it is important that you find an attorney who is familiar with the local real estate law, because they can be different from either northern New Jersey to southern New Jersey, and that's very important when it comes to handling that transaction. And also, another good thing that anyone should do is simply ask questions. There have been people that you may know, even friends or family, who have had a relationship with an attorney and had a similar transaction to your own.
Judge, I know everybody here is entitled, all the tenants are entitled to an implied warranty of habitability. Well, that's a legal phrase. What does it mean in common everyday English?
That means you must have a decent apartment in which to live. Very, very simple. And it's a little more than just having the four walls in the apartment.
Well, if my apartment is rent stabilized, am I entitled to a painting?
You're entitled to a painting. It was formerly every 3 years under the new section. That's been changed a little. There's going to be various interpretations. I know on my own lease, I just received the renewal which stated that I'm entitled to a paint job, but since there's only a 2-year lease now, I have to pay for a proportionate share of that 1 year for the painting. How that's going to be held up in the courts remains to be seen. I may have the advantage because I happen to be a tenant myself.
Jerry, if someone is interested in purchasing a co-op, now I know that in co-ops the board has to approve the potential person purchasing it.
That is correct.
What should they keep in mind? Is there something that they say to the board that they should say? Is there something they shouldn't say? I know they often call down for a personal interview. What's your recommendation?
Well, the board interview is something that is becoming much more important today as more and more buildings turn to their cooperative ownership. Boards are very concerned of who their tenants are. My recommendation to my clients is to be themselves, to be relaxed, to go down and show to the board who these people are. The boards will require certain financial information to be sure that the purchaser has the potential to maintain his apartment and make his maintenance payments. But the procedure is one that would require someone to just go forward and be themselves.
Jerry, I recently read about a case in the New York Times where a board was sued for racial discrimination. And it was a federal court case, and the judge said, yes, he can see this board racially discriminated against this one particular plaintiff. Can you comment on that?
Well, overall, boards have tremendous discretion. The the courts have permitted in the finding of boards that the board in their own determination and wisdom can rule on who they should not have in their building. When we have in New York certain laws about discrimination, a board cannot go against the law, cannot withhold their consent based upon any kind of certain minority, be it whether it be a color or a religion. But the boards do have tremendous control, and that's a major factor to consider.
Do you have a comment on that, Judge?
The federal court decided basically the same as New York. The case brought in the federal court was under the civil rights law, and the judge stated that you just cannot say that we're not going to give a reason why we turn someone down. That there are times you're going to have to explain, especially if there is a financially viable tenant. You're going to have to give some type of an explanation why that party is turned down. And in this particular situation, the court found that the turn down was racially motivated.
For a different topic, Judge, if I have a rent-stabilized apartment or I have a rent-controlled apartment, are there ways that the landlord can legitimately get me out of my status?
Well, there's the one way that he can always get you out is if you don't pay your rent. I mean, that is always the grounds for an eviction. The other ground, there is one ground that we've been going back and forth on, but we're now back in year one, I would say, where if he needs it for his own immediate use or the immediate use of a very close member of his family, like a child, where he could possibly obtain that apartment.
Is it different if I'm a senior citizen?
Yes, it is certainly different, because if you're a senior citizen, you would be protected.
Arthur, in the few remaining moments, if you have to say something to our viewers of New Jersey about purchasing real estate, what would that be?
The one thing I would say, Alan, is that any document that you sign, make sure that it has the now required 3-day attorney review period involved, so that you can immediately take that contract, no matter who draws that contract, to your attorney. The attorney is invaluable in protecting your rights when you purchase real estate. You know, the real estate industry in this country is a $75 billion to $100 billion industry. It's the largest business that we have, and it's also, for most individuals, the single most important investment they're going to make.
Jerry, what's your comments? We have to make it
I would
quick.
say they're making a wise investment and get themselves a good lawyer.
And Judge, for tenants and landlords who come before your court, what's your advice?
Well, if you can afford a lawyer, get one. It's not a necessity in landlord-tenant court.
Jerry Colston, Arthur Weiss, Judge Rubin, thank you very much. This is Alan Schnorman, and thank you for watching Lawline.
You have been listening to Lawline with your host, New York lawyer Alan Schnorman. Mr. Schnorman will be back with you again next week at this same time.